Chapter 7 of the South African Law of Persons, 6th edition by Jacqueline Heaton. The topic for Chapter 7 is mental illness. Under Chapter 7, we have 7.1 Introduction, 7.2 Definition, 7.3 Proving mental illness, 7.4 Legal status of a person with a mental illness, 7.5 Appointment of a curator, 7.6 Mental Health Care Act 17 of 2002, 7.6.1 Definition, 7.6.2 Rights of mental health care users, 7.6.3 Care, treatment and rehabilitation, 7.6.4 Place of admission, 7.6.5 Mentally ill prisoners and state patients, 7.6.6 Care and administration of the property of mentally ill persons. Just before we continue, thank you so much for listening. Please take a few seconds to like this and previous videos if you found them helpful, and please also subscribe to our channel, The Helpful Voice. 7.1 Introduction. The capacity to enter into legal transactions and to litigate independently is very closely related to a person's mental condition. For this reason, the law precludes a person from participating in legal interaction independently if he or she has a mental illness to such a degree that he or she cannot understand the nature, purport, and consequences of his or her acts. See footnote 1. The law attaches no consequences whatsoever to the expressions of will of a person with such a mental illness. Thus, such a person has no capacity to act or to litigate. See footnote 2. The object of this restriction is not to punish the person, but to protect him or her from exploitation. 7.2 Definition. At common law, mentally ill persons as a class were confined to furiosi, dementes, or lunatici. See footnote 3. These terms clearly relate to persons who are so bereft of their senses that they cannot grasp the consequences of their acts and cannot make rational decisions at all. In modern law, the courts ascribe a much wider meaning to mental illness. See footnote 4. In Pheasant v. 1, see footnote 5, Chief Justice Innes held that the test was whether the person's mind was such that he could understand and appreciate the transaction into which he purported to enter. In quotes. In Langer v. Langer, see footnote 6, the Appellate Division, which is now the Supreme Court of Appeal, held that a person is mentally ill not only if he or she cannot understand the nature of the transaction in question, but also if he or she does understand the nature and consequences of his or her juristic acts, but is motivated or influenced by delusions caused by a mental illness. See footnote 7. In this case, a man had married while suffering from a mental condition which inter alia, among other things, caused him to hear imaginary voices. Although at the same time of the wedding, the man had understood the nature of the juristic act, the court held that the marriage should be declared null and void on account of his mental illness. 7.3 Proving mental illness. Whether or not a person was mentally ill at a specific moment is a question of fact which must be determined on a preponderance of probabilities. See footnote 8. It is the person's mental capacity at the time of the conclusion of the transaction that is at issue. So just quickly here, if you can just go a bit deeper into defining preponderance of probabilities. It says here, preponderance of probability or preponderance of the evidence is a legal standard of proof primarily used in civil cases that requires a party to convince the judge or jury that a particular fact or event is more likely to be true than not true. It signifies that the scales of probability are tipped in favor of one side, but it does not require absolute certainty or proof. Medical evidence is usually crucial in proving mental illness. The court must, however, make its own finding after considering all the evidence and is not bound even by the unanimous opinion of psychiatrists. As judges are not experts in the psychiatric field, a court will not lightly reject the opinions of expert witnesses. See footnote 9. It will only do so if, in its view, the experts have based their opinion upon inadequate knowledge of the relevant facts or have ignored such facts. See footnote 10. 7.4. Legal status of a person with a mental illness. The statutory measures relating to mental health care and the certification and administration of a mentally ill person's estate must be clearly distinguished from the legal principles governing the person's legal status. In general, a mentally ill person's status is determined by common law principles as interpreted and extended by the courts. See footnote 11. However, as is explained below in this chapter, Section 39, subsection 1 of the Consumer Protection Act 68 of 2008 adds a specific rule in connection with agreements that fall within the ambit of this act. The measures relating to mental health care and the certification and administration of a mentally ill person's estate are contained in the Mental Health Care 17 of 2002. The Act is discussed below in this chapter. We first consider the person's legal status. Insofar as mentally ill person's status is concerned, it was pointed out above that the person has no capacity to act or locus standi in judicio. Let's just quickly go back to define this. So, locus standi in judicio refers to the legal right of a party to bring a lawsuit or participate in legal proceedings. So it signifies that a person has a direct, substantial, and adequate interest in the matter before the court to warrant their title to prosecute the claim. Consequently, a mentally ill person cannot enter into legal transactions or litigate even with the assistance of his or her curator. The curator must conclude transactions and sue on behalf of the mentally ill person. See footnote 12. From this, it follows that a mentally ill person, unlike a minor, cannot enter into transactions, even if he or she acquires only rights and the other party incurs only duties. See footnote 13. Any transaction a de facto mentally ill person enters into is void and cannot be ratified. See footnote 14. So just quickly, if we remember that when we say de facto or de facto, we mean in fact. whether by right or not. Okay. The transaction remains void, even if the person dealing with the mentally ill person was unaware of the mental illness. See footnote 15. A bona fide third party, so bona fide is a Latin word for good faith or with honesty or with sincerity. A bona fide third party can therefore not insist on the agreement being carried out, but may have an action based on unjustified enrichment. See footnote 16. Because enrichment liability is not based on contract and capacity to act. A mentally ill person can also be liable on the basis of negotiatorium gestio. See footnote 17. In terms of the common law, a judicial declaration that a person is mentally ill, that is, certification, and the appointment of a curator to the person do not, as such, affect the person's liability and capacity to act. See footnote 18. In other words, someone who has not been certified does not have capacity to act if he or she is in fact mentally ill when the transaction is entered into. And a person who has been certified has capacity to act if he or she is in fact not mentally ill at the time the juristic act is performed. The legal position is thus determined by whether or not the person was actually mentally ill at a specific moment. See footnote 19. Certification is important only as far as the onus of proof is concerned. In the case of an uncertified person, the onus of proof is on the party alleging that the person was mentally ill at the time the transaction was concluded, because it is ordinarily presumed that everyone is sane. See footnote 20. In contrast, in the case of a certified person, the onus is on the party alleging that the person was sane at the conclusion of the transaction, because it is rebuttably presumed that a certified person is mentally ill. See footnote 21. A juristic act that is performed during a lucidum intervallum, that is, a lucid interval, by a person who has been declared mentally ill is valid and enforceable. See footnote 22. Section 39, subsection 1, paragraph A of the Consumer Protection Act creates a different rule with regard to transactions governed by the Act. See footnote 23. It provides that an agreement to enter into a transaction for the supply of any goods or services and an agreement for the supply of any goods or services to a consumer, see footnote 24, is void if the customer is subject to an order of a competent court holding that person to be mentally unfit and the supplier knew or could reasonably have determined that the customer was the subject of such an order. See footnote 25. Thus, this section renders all such agreements, even those which the person enters into during a lucidum intervallum, void if the supplier knew or could reasonably have determined that the consumer has been declared mentally ill. This rule, which clearly has the objective of protecting people with a mental illness, renders all persons who have been declared mentally ill incapable of entering into agreements with a supplier who knows or could reasonably have established that the person has been declared mentally ill. And this incapacity operates regardless of the de facto mental condition of the person at the time of the particular agreement. In laying down this restriction, The section violates the right to equality and the right to dignity of persons who have been declared mentally ill. See footnote 26. It is submitted that the scope of this limitation is too broad to render it justifiable in terms of Section 36 of the Constitution, since it does not provide for any exception to the rule that the agreement is void, not even if the agreement is advantageous to the consumer. A marriage or civil union is not automatically dissolved by the mental illness of one of the spouses or civil union partners. See footnote 27. However, in terms of the Divorce Act 70 of 1979, see footnote 28, mental illness for which there is no reasonable prospect of a cure is a ground for divorce. If a spouse or civil union partner's mental illness results in the irretrievable breakdown of the marriage or civil union, a divorce may also be sought on this ground. See footnote 29. In a marriage or civil union in community of property, the court may suspend the power of a mentally ill spouse or civil union partner to deal with the joint estate for a definite or indefinite period if suspension is essential for the protection of the interest of the other spouse or civil union partner in a joint estate. See footnote 30. At common law, a spouse's mental illness was not sufficient reason for ordering bodelscading. See footnote 31. So bodelscading, just very quickly, is the division of property or division of an estate. However, in terms of the Matrimonial Property Act 88 of 1984, the immediate division of the joint estate may be ordered if the same spouse or civil union partner satisfies the court that his or her interest in the joint estate is being or will probably be seriously prejudiced by the conduct or proposed conduct of the other spouse or civil union partner, and that no other person will be prejudiced by the division. See footnote 32. In a marriage or civil union out of community of property, which is subject to the accrual system, the same spouse or civil union partner may ask the court to make an order for the immediate division of the accrual. The order will be made if the applicant satisfies the court that the conduct or proposed conduct of the other spouse or civil union partner seriously prejudices or will probably seriously prejudice the applicant's right to share in the accrual of the estate of the other spouse or civil union partner at the dissolution of the marriage or civil union, and that no other person will be prejudiced by the order. See footnote 33. A parent's mental illness does not automatically terminate his or her parental responsibilities and rights. See footnote 34. Exercising its common law authority as upper guardian of all minors or its various statutory powers, the court may, however, make an appropriate order in respect of any or all the elements of the parent's responsibilities and rights if this is in the best interests of his or her child. See footnote 35. The running of prescription against a person cannot be completed while he or she has a mental or intellectual disability, disorder, or incapacity. See footnote 36. There are numerous offices a mentally ill person cannot hold. See footnote 37. Generally speaking, fault in the form of intention or negligence is a requirement for criminal or civil liability. As a mentally ill person is doli and culpa impacts, he or she is not responsible for his or her crimes and delicts. See footnote 38. So when we say that a mentally ill person is doli and culpa in capex, just to explain further, in legal context, the term doli typically refers to a child's mental capacity to understand right from wrong. So it often appears in the Latin phrase doli in capex, meaning incapable of wrong or incapable of evil. This legal maxim presumes that very young children lack the criminal responsibility for their actions and cannot form criminal intent. So basically, this is what a mentally ill person is described as. Hence, they are not responsible for their crimes and their delicts. 7.5 Appointment of a curator. See footnote 39. In terms of our own common law, the High Court may appoint a curator bonus to look after a mentally ill person's property and to supplement his or her lack of capacity to act. See footnote 40. In terms of the Mental Health Care Act, the court also has a statutory power to appoint an administrator for the care and administration of the property of a mentally ill person or a person with severe or profound intellectual disability. This statutory power is discussed in the chapter below. So we know when we are talking about a curator bonus, we are talking about someone who represents someone who is unable to represent themselves in court or in legal proceedings. It is important to note that the fact that a person has been declared mentally ill and that a curator has been appointed to administer his or her estate does not mean that he or she loses capacity to act. In Pienaar versus Pienaar Curator, see footnote 41, Judge President de Villiers stated, "The mere fact that such a person has been declared insane or incapable of managing his affairs and that a curator is appointed to such a person does not deprive him of the right of administering his own property and entering into contracts and other legal dispositions to the extent to which he may de facto be capable, mentally and physically, of so doing." Such mental or physical capacity may vary from day to day, but at all times it remains a question of fact. The object of appointing a curator is merely to assist the person in question in performing legal acts to the extent to which such assistance is from day to day in varying degrees necessary. Thus, even a person who has been declared insane and to whose estate a curator has been appointed can dispose of his property and enter into contracts whenever he is mentally capable of doing so. Acts that are considered to be of a very personal nature cannot be performed by a curator. For example, a curator has no locus standi to institute an action for divorce on behalf of a mentally ill person. See footnote 42. Nor can a curator make a will or exercise parental responsibilities and rights on behalf of a mentally ill person. See footnote 43 and 44. In legal proceedings, a mentally ill person must be represented by a curator ad litem. See footnote 45, because the law denies a locus standi in judicio to someone who is unable to understand the proceedings. See footnote 46. If a person lacks the necessary mental capacity when instructing an attorney to litigate on his or her behalf, the instruction is invalid. See footnote 47. However, the legal proceedings which follow are of full force and effect if the person's curator ad litem ratifies the legal steps taken as a result of the instruction. See footnote 48. If necessary, a curator is appointed to care for the mentally ill person's person, that is the person's body, either generally or for a specific purpose. Read footnote 49. Such a curator is called a curator personae. As the appointment of a curator personae involves a serious curtailment of a person's rights and freedoms, it is not made lightly. See both footnotes 50 and 51. So a very interesting word to use, curtailment, which means the action or fact of reducing or restricting something. So since being a curator personae is seriously restrictive or seriously reduces or it cuts back on a person's rights and freedoms, this appointment is not made lightly. 7.6 Mental Health Care Act 17 of 2002. 7.6.1 Definition. The fundamental concept in the Mental Health Care Act is that of mental health care user, which Section 1 defines as a person receiving care, treatment, and rehabilitation services or using a health service at a health establishment aimed at enhancing the mental health status of a user, state patient, and mentally ill prisoner. In certain circumstances, the phrase extends to a prospective mental health care user, the person's next of kin, someone who has been legally authorized to act on that person's behalf, an administrator appointed in terms of the Act, and the executor of a deceased mental health care user's estate. A person's mental health is the level of mental well-being of an individual as affected by physical, social, and psychological factors and which may result in psychiatric diagnosis. See footnote 53. 7.6.2 Rights of mental health care users. The object of the Act are the regulation of mental health care, treatment, and rehabilitation services, and the manner in which the property of mentally ill persons and persons with severe or profound intellectual disability may be dealt with, and the clarification of the rights and duties of mental health care users and providers. See both 54 and 55. The Act, inter alia, contains a separate chapter setting out specific rights and duties mental health care users have. See footnote 56. These rights and duties operate in addition to the rights other laws confer on mental health care users. Footnote 57. Whenever these rights or duties are exercised or performed, regard must be had to the best interests of the mental health care user. See footnote 58. The rights of mental health care users include the right to representation, including legal representation, confidentiality, having their person, human dignity, and privacy respected, and being provided with care, treatment, and rehabilitation services that improve their mental capacity to develop to their full potential and to facilitate their integration into community life. See footnotes 59, 60, and 61, and footnote 62. Care, treatment, and rehabilitation services may not be used as punishment or for the convenience of other people, must be proportionate to the mental health care user's mental health status, and may intrude only as little as possible to give effect to the appropriate care, treatment, and rehabilitation. See footnotes 63 and 64. Except in urgent cases, mental health care users must be informed of their rights prior to the administration of any care, treatment, and rehabilitation services. See footnote 65. The Act also prohibits unfair discrimination on the ground of a person's mental health status and provides that any determination concerning a person's mental health status must be based solely on factors that are relevant to his or her mental status and not on socio-political or economic status, cultural or religious background, or affinity. See footnote 66 and 67. A determination of a person's mental health status may be made only for purposes that are directly relevant to his or her mental status. See footnote 68. Every person, body, organization, or health establishment which provides care, treatment, and rehabilitation services must take steps to ensure that mental health care users are protected from exploitation, abuse, degrading treatment, and forced labor. See footnote 69. The Act furthermore requires all state organs to determine and coordinate the implementation of their policies and measures in a manner that promotes the rights and interests of mental health care users. See footnote 70. Many of the rights set out in the Mental Health Care Act reflect the obligations imposed on South Africa by the Convention on the Rights of Persons with Disabilities. South Africa ratified the convention in 2007. The definition of persons with disabilities in Article 1 of the Convention includes persons who have long-term mental or intellectual impairments which in interaction with various barriers may hinder their full and effective participation in society on an equal basis with others. In terms of the Convention, South Africa is obliged, inter alia, to respect the inherent dignity, physical and mental integrity, and privacy of persons with disabilities. See footnote 71. It must also recognize the right to equality of persons with disabilities, prohibit all discrimination on basis of disability, guarantee equal and effective legal protection against discrimination, and recognize that persons with disabilities enjoy legal capacity, in quotes, on an equal basis with others in all aspects of life. See footnote 72. Effective measures must be taken to prevent persons with disabilities from being subjected to torture or cruel, inhuman, or degrading treatment. See footnote 73. Persons with disabilities must also be protected from all forms of exploitation, violence, and abuse. See footnote 74. 7.6.3 Care, Treatment and Rehabilitation. The Act distinguishes between different categories of persons requiring mental health care on the ground of whether or not they voluntarily submit to mental health care and admission. The basic premise is that care, treatment, and rehabilitation services may only be provided, and a mental health care user may only be admitted to a health establishment if one of the following circumstances is present. 1. The mental health care user consents to it. 2. A court or mental health review board authorizes it. See footnote 75. 3. Due to the mental health care user's mental illness, any delay in providing the services may result in A. A mental health care user's death. B. Irreversible harm to the mental health care user's health. C. The mental health care user inflicting serious harm on himself or herself or somebody else. Or D. The mental health care user causing serious damage to or loss of his or her own or somebody else's property. See footnote 76. If the services are provided or the admission occurs in the circumstances of urgency referred to in paragraph 3 above, the health care provider or health establishment must report this to the Mental Health Review Board. Unless an application is made for voluntary, assisted, or involuntary mental health care within 24 hours, the services may not be provided for more than 24 hours. See footnote 77. A. Voluntary care, treatment, and rehabilitation. A person who voluntarily submits to treatment and admission while being capable of making informed decisions in this regard may be treated and admitted without court intervention. Such a person is entitled to appropriate care, treatment, and rehabilitation services, or to be referred to an appropriate health establishment. See footnote 78. B. Assisted care, treatment, and rehabilitation. A person who is incapable of making informed decisions due to his or her mental health status, but who does not refuse health interventions, is referred to as an assisted mental health care user. See footnote 79. Assisted care, treatment, and rehabilitation services may only be administered to a person without his or her consent if the head of a health establishment approves a written application for the provision of such services, and there is a reasonable belief that at the time of making the application that the mental health care user is suffering from a mental illness or severe or profound intellectual disability and requires those services for his or her own or other people's health or safety. See footnote 80. The application must be made by the mental health care user's spouse, civil union partner, next of kin, partner, associate, parent, or guardian. See footnote 81. If that person is unwilling, incapable, or not available to make the application, a health care provider may make the application. See footnote 82. In either case, the applicant must have seen the mental health care user within 7 days prior to making the application. See footnote 83. Upon receipt of the application, the head of the health establishment must have the mental health care user examined by 2 mental health care practitioners. See footnote 84. The application may only be approved if the practitioners agree that conditions for assisted care, treatment, and rehabilitation are present. See footnote 85. An application for admission to a health establishment may only be approved if the practitioners agree that admission is necessary and the head of the establishment is satisfied that the restrictions and intrusions on the mental health care user's rights to freedom of movement, privacy, and dignity are proportionate to the care, treatment, and rehabilitation services required. See footnote 86. If the application is approved, the Mental Health Review Board must be notified. The review board must conduct an investigation and then either request the head of the health establishment to continue providing services to the mental health care user or request the person's discharge. The review board must report its findings to the head of the provincial department. See footnote 87. The mental health care user or his or her spouse, civil union partner, next of kin, partner, associate, parent or guardian may lodge an appeal against the decision of the head of the health establishment with the review board. See footnote 88. 6 months after commencing care, treatment and habilitation services, and once a year thereafter, the head of the health establishment must have the person's mental health status reviewed and submit a report to the review board. See footnote 89. If the review board decides that the person must be discharged, all care, treatment, and rehabilitation services administered to him or her must be stopped according to accepted clinical practices, and he or she must be discharged unless he or she consents to receiving services. See footnote 90. If the head of a health establishment has reason to believe that the assisted mental health care user has recovered the capacity to make informed decisions, the person must be asked whether he or she will voluntarily continue receiving services. See both footnotes 91 and 92. If the person is willing to continue, he or she becomes a user of voluntary services. If the person is unwilling, he or she must be discharged if the head of the establishment is satisfied that the person is no longer mentally ill. However, if the head of the establishment is of the view that the person is still mentally ill, the person who applied for assisted services for the mental health care user and the mental health care practitioner, registered social worker, or nurse administering these services must be informed and advised that they have 30 days within which to apply for the person's involuntary commitment. See footnote 93 and 94. If an application for involuntary commitment is not made within the period, the mental health care user must be discharged. See footnote 95. C. Involuntary care, treatment, and rehabilitation. If the mental health care user is incapable of making informed decisions on the need for care, treatment, and rehabilitation services and does not want such services, involuntary services must be provided to him or her if the head of a health establishment approves a written application for the provision of such services. See footnote 96. At the time of making the application, there must be a reasonable belief that the mental health care user has a mental illness of such a nature that he or she is likely to inflict serious harm on himself or herself or others, or that care, treatment, and rehabilitation services are necessary for the protection of his or her financial interests or reputation. See footnote 97. As in the case of assisted services, the application must be made by the mental health care user's spouse, civil union partner, next of kin, partner, associate, parent or guardian, or if they are unwilling, incapable, or not available to make the application, by a healthcare provider. See footnote 98. The applicant must have seen the mental health care user within 7 days prior to making the application. See footnote 99. Upon receipt of the application, the head of the health establishment must have the mental health care user examined by 2 mental health care practitioners. See footnote 100. The application may only be granted if the practitioners agree that conditions for involuntary care, treatment, and rehabilitation are present. See footnote 101. Up to this point, the procedure is the same as that which applies in respect of assisted services. However, in the case of involuntary services, the mental health care user must be referred for a 72-hour assessment period prior to the further provision of involuntary services. This assessment is done by a medical practitioner and another mental health care practitioner. Their task is to evaluate the mental health care user's physical and mental health status and to consider whether he or she must continue receiving involuntary services and be involuntarily committed. See footnote 102. After the assessment, the head of the establishment must discharge the mental health care user immediately if he or she is of the opinion that the person's mental health status does not warrant involuntary care, treatment, and rehabilitation. However, if the mental health care user consents to receiving services, he or she need not be discharged. If the head of the establishment is of the opinion that the person's mental health status indeed warrants further involuntary services but does not warrant commitment, the person must be discharged subject to the prescribed conditions and procedures for outpatient care, treatment, and rehabilitation, and the review board must be informed. If the head of the establishment is of the opinion that the person's mental health status warrants involuntary commitment, he or she must submit a written request to the review board for approval of further involuntary care, treatment, and rehabilitation on an inpatient basis. See 103. If the review board grants the request, the matter must be referred to the High Court. See 104. After considering all the information, the High Court may either order the mental health care user's immediate discharge or his or her further hospitalization. See 105. If necessary, an administrator may be appointed to care for and administer the person's financial affairs. The mental health care user or his or her spouse, civil union partner, next of kin, partner, associate, parent, or guardian may lodge an appeal against the decision of the head of the health establishment with the review board. See 107. 6 months after the commencement of involuntary services and once a year thereafter, the head of the health establishment must have the person's mental health status reviewed and submit a report to the review board. See 108. If the review board decides that the person must be discharged, all care, treatment, and rehabilitation services must be stopped according to accepted clinical practices, and the person must be discharged unless he or she consents to receiving services. C-109. If the head of the establishment has reason to believe that an involuntary mental health care user has recovered the capacity to make informed decisions, he or she must inquire whether the person is willing to voluntarily continue receiving services. C 110 and 111. If the person is willing to continue, he or she becomes a user of voluntary services. If the person is unwilling, he or she must be discharged if the head of the establishment is satisfied that he or she is no longer mentally ill. See footnote 112. D. Report by a member of the police. A member of the police who has reason to believe, see footnote 113, that someone is likely to inflict serious harm on himself or herself or others because of mental illness or severe or profound intellectual disability must arrest that person. The person must be taken to a state-controlled health establishment for assessment of his or her mental health status and handed over into custody of the head of the establishment or someone the head designates. See footnote 114. If, after the assessment, a mental health care practitioner shares the view of the member of the police, the person must be admitted to the health establishment. Within 24 hours of the person's admission, an application must be made to obtain involuntary care, treatment, and rehabilitation services for him or her. See footnote 115. If, in contrast, the mental health practitioner is of the view that the person is unlikely to cause harm, the person must be released immediately. See footnote 116. The police may also be used to locate, apprehend, and return an assisted or involuntary mental health care user who has absconded or is deemed to have absconded from a health establishment. And when an assisted or involuntary mental health care user is transferred to another healthcare establishment. See footnote 117. 7.6.4 Place of admission. Mental health care users may only be admitted to health establishments. See 118. 7.6.5 Mentally ill prisoners and state patients. The Act also governs the confinement of and provision of mental health care to mentally ill prisoners and state patients. See footnote 119. As the relevant provisions apply only to persons who have committed criminal acts, they fall outside the scope of this book. 7.6.6 Care and administration of the property of mentally ill persons. If a high court conducts an inquiry into a person's mental health and the presiding judge has reason to believe that the person may be incapable of managing his or her property, the judge may initiate an investigation into the person's mental health status and ability to manage his or her property. The court may exercise this power in any other legal proceedings too. See footnote 120. If the investigation reveals that the person's mental health status is such that he or she is indeed incapable of managing his or her property, the court makes a recommendation regarding the appointment of an administrator and informs the person and the Master of the High Court accordingly. See footnote 121. The Master then appoints an administrator to take care of and administer the person's property, to perform all functions incidental thereto, and to carry on the person's business or undertaking, if any. See footnote 122. The Master may also, upon application by an adult, appoint an administrator in respect of the property of a mentally ill person or a person with severe or profound intellectual disability. See 123. Instead of appointing or declining to appoint an administrator, the Master may refer the matter for consideration by a judge in chambers. See 124. After considering the matter, the judge makes a recommendation to the Master on whether or not an administrator should be appointed. If the judge recommends appointment of an administrator, the Master appoints the administrator. See 125. The power to appoint an administrator does not replace the court's common law powers to appoint a curator to a mentally ill or intellectually disabled person. Chapter 7 ends. And in our next chapter, which is chapter 8, the topic is inability to administer affairs owing to reasons other than mental illness. Hey there, thank you for listening. If this was helpful to you, please take a minute to subscribe, like, comment, and share.